Brady versus the Williams Capital Group. Counsel, would you like any rebuttal time?
Yes, Your Honor. I'd like 3 minutes for rebuttal.
3 minutes. Go ahead.
Thank you, Your Honor. May it please the Court, my name is Mark Silverman, the law firm of Schiff Hardin in New York. I represent Williams Capital Group in connection with this appeal. This appeal is being taken from a determination of the Appellate Division First Department, which reversed the decision of Justice Figueroa in the New York State Supreme Court. The Appellate Division decision is taken as of right. The appeal from the Appellate Division decision is taken as of right in that there was a 31-page dissent written by Justice McGuire, which adopted Justice Figueroa's determination with respect to the issue of whether or not the AAA's employer pays rule trumps the parties' arbitration agreement. The Appellate Division held that it did not. Justice Figueroa held that it did not, and we submit that that's correct. But it's there that we part company. At least the dissent and I part company from the majority. The majority in the Appellate Division erred in 3 different ways. First, it held that the fee-splitting provision of the arbitration agreement was void as against public policy. We submit, as we'll show in a minute, all the reasons why it was incorrect, in that there was not a sufficient showing by Brady that she could not pay for the arbitration and meet the other standards under Greentree and its progeny, the Bradford case. Second,
is that a requirement that each employee must show that they cannot pay their portion of the fees?
Well, if you have to understand the context in which this arose. Unlike a lot of other cases, Williams Capital did not move to compel arbitration. This was the determination of Ms. Brady to move to go to arbitration. And by the way, we did not only did we not move to compel arbitration, but Ms. Brady first went to the State Division of Human Rights, spent 8 months at the State Division of Human Rights litigating before she decided to go to arbitration. And we did not compel her to do that. We allowed her to do that. We were prepared to litigate in any forum.
Okay. What did she have to show then? What are you saying she had to show?
Under Bradford, there are three criteria. Under Greentree and its progeny, the burden is on her. Well, I want to establish that right from the outset, that it is her burden, not Brady's burden. It is her burden to show that the fee-splitting provision would be a headwind and prohibitively expensive to allow her to go to arbitration. And under Bradford, and most courts have agreed with the Bradford decision in the Fourth Circuit, that there are several criteria that she has to meet. The first criteria was her ability to pay. What does the record say with respect to her ability to pay? The majority said that she met that standard. We say that she didn't meet that standard at all.
Why should we disturb their finding?
Because, well, as the dissent indicated, the record is virtually barren.
Well, we know that unemployment and that is X amount of dollars to pay half, but that we know, and the majority, found that that's sufficient.
Yeah, and as a matter of law, we say that that's insufficient, that the mere fact that she was unemployed for some period of time does not meet the high standard that she's required to meet to show that she was unable to pay.
Where does it say that?
Well, Your Honor, if the Greentree and the Bradford case and cases subsequent to that indicate that there is a higher standard of proof, that there are more facts that that need to be laid out on the record in order for her to meet that standard. Now,
in the procedural posture, are we treating this as though summary judgment had been granted, granted against you on this issue, or do we treat this as though the lower courts had found facts and the findings are binding if they're supported by the record?
Well, I believe this is a de novo review. This is treated as initially as a motion as an Article 78 proceeding, and then it's treated as a motion to compel arbitration.
Yeah, I guess I'm asking.
Does that mean it can be sent back for fact-finding on her
No,
financial
I don't believe.
status?
No, I don't believe it can. I think that that there has to be a determination here. The Appellate Division.
In an article, is it Article 78, Article 75, whatever it is, as I I'm not sure I do understand it, but would I be correct in understanding that the courts can find facts, even on a paper record, without holding a trial, and those fact findings should be given the same kind of deference we would give to findings in a non-jury trial?
Well, those facts, even if they're given deference, do not rise to the level of the
Okay, but I'm just asking what you understand the standard to be. I mean, I understand you, yeah, I know that you say whatever the standard is, you win, but what's the standard?
On ability to pay.
No, the standard, what is the standard of review of factual findings below? If we think there's a disputed issue of fact, in which either result could reasonably, either fact could reasonably have been found on this record, are we bound by the findings below?
Well, I think you have de novo review of these. And
Why wouldn't
where
we-
is it going to go back to? Is it going to go back to Justice Figueroa or the appellate, not the appellate division to find fact? The appellate division
Can we
already.
look at it totally fresh?
Pardon me?
No, we look at it totally fresh. There's no deference to the fact finding? That they met the burden?
I don't think there's any deference to the appellate division's fact finding in this particular case, no?
So why, I mean, you have, what you have is you have the $21,000, a lot of money for the average human being who's out of work. Why isn't it reasonable to find from that it's enough it's such a burden on arbitration that arbitration is not reasonably available?
Because under the Green Tree, United States Supreme Court decisions and a line of cases that follow it, it must be prohibitively expensive. Now, on its face, $21,000 may seem like a lot of money. But what facts did she elicit
Well, there's
in
two
connection
things.
with her other assets? None. And she arrogated herself to the position, I don't have to disclose what my assets are. And I'm sorry, Your Honor.
Oh, please, I'm sorry, I do this all. Go ahead.
And
finish.
with respect to the issue of unemployment insurance, unemployment, she said that she was unemployed for 18 months. She has to do more than come forward and say, I'm unemployed for 18 months. She could have voluntarily absented herself from the labor market. We don't know.
Didn't you have a tremendous advantage? I mean, we don't know how much money you got either, your corporation. But the things that go into a determination to even commence a lawsuit are the chances of winning. You know, obviously your ability to pay things like this. And are we when you say prohibitively expensive, as they say, is that some objective standard that, if it's a janitor, $42,000 is prohibitively expensive. If it's the vice president, $42,000 prohibitively expensive. And if we're going to do a graduation on that side, if we say depending on your job, this may or may not apply, why don't we take all these factors into consideration? And to finish my long question, it seems to me that now this becomes a weapon. That in certain circumstances, a corporation which can easily handle this can say, we've got the AAA. This person had no clue when she signed her employment agreement that AAA was going to charge $50,000 for her to test her rights, and so we don't have to worry about this anymore because we can her, and she's not going to be able to afford the arbitration, and we win.
Well, except that we made it clear in the arbitration agreement that the parties would split the fees of the arbitrator.
But did anybody know it was going to be $42,000?
Nobody ever knows, Your Honor.
No, I don't think
whether it's
AAA
the most sophisticated party or the least
Yeah,
sophisticated
but isn't
party.
that how we get to this burden issue? That we know from Bradford that, basically, that if you have to pay half of it or whatever it is, you have to be able to pay. Otherwise, it's against public policy, right?
That's precisely right.
And then we have the majority finds she meets the burden. The dissent says she doesn't. And how do we choose between that? Because as Judge Pickett just said, what's the objective test? How do we know? I mean, $21,000 to me is a lot of money, and being out of work for 18 months is a long time. Couldn't one reasonably say that that's prohibitively expensive to someone who walks into this contract and who is at a disadvantage, at least vis-a-vis you, in terms of what's going to be entailed in these kinds of arbitration proceedings,
Well, that's
right?
precisely why there is no per se rule that a fee-splitting provision is against public policy.
Well,
That's
there are
exactly why it's an individual.
some per se rules, right, like in D.C., that says that You know, it's always against public policy, right?
And I'm not aware of the case you're referring to, Your Honor.
There is a minority view that it's always against, right?
Well, I don't think Greentree and the Supreme Court would agree with that. If they did reach that conclusion, I think the Supreme Court has said that in effect there is no per se rule. It's an individualized rule, and yes, it can float varying with the circumstances. But the point is that the burden is on Ms. Brady here to come
Suppose
forward.
the number were 210,000 instead of 21,000. Would you still say she had to put in an affidavit?
The answer to that is yes. She still has to make a showing. She still has to show that it is prohibitively expensive, because she could have $10 million in assets from an investment, and she never came forward and said.
Well, suppose she did have 10 million, but she's only got a $500,000 claim, and the AAA wants $250,000 to litigate it. Can she reasonably say no, that's unreasonable? I'm not going to do it.
That's ultimately for a court to determine in light of all the circumstances. What are her assets, number one? And, of course, there are other tests, too. The other tests are the comparison between the cost of litigation versus the cost of arbitration. She never came forward and made any kind of a showing to show that the cost of arbitration.
What about we didn't ask Mr. Schreiber to make any kind of a showing. He was facing a $10,000 filing fee, and we said that's ridiculous. You can't make him do that. Why is this case different?
Well, this case is different because, number one, I don't know all of the circumstances surrounding his financial capability. But all I know is that the Court did not invalidate the clause. The Court didn't sever the clause the way the appellate division did here.
You're really on your second point now. You're saying that even if there is an excessive burden, then it's remedied by giving the claimant the option of going to court.
Well, yes, and as in the Schreiber case, the Court made it implicitly clear that if the employer wanted to pay for it, then he could compel arbitration.
Okay.
Again, that's the
You're
employer
almost out of
compelling
town. Could you
arbitration.
address for a minute? I understand your point, that in Schreiber we said your choice is to go to pay the money or go to court. Why doesn't the severability clause here change that result?
The severability clause changes the result. First of all, the severability clause was never raised below. Ms. Brady had multiple opportunities over 24 months to raise the issue of severability, and she never did.
I understand that point, too. Suppose it had been. Why doesn't it change the result?
We didn't have a chance to argue that, Your Honor.
Okay. Argue it now. That's what I'm asking you to do.
Because that's a matter of State law. It's a matter of State law. It's a matter of the intent of the parties on the severability clause. I believe it's the Wilson case that makes it clear that that's a matter that the intent of the parties with respect to severability, particularly where there's a severability is an issue of fact and law.
Are you saying there's evidence you could have introduced, that if it had been raised below, there's evidence you could have introduced?
Precisely.
Okay, but can you, I know your red light's on, but can just, putting aside all the procedural problems with the argument, on the merits, suppose you have this record, you have a severability clause, and no evidence has been introduced. Forget about the fact that maybe you didn't have the chance to introduce it. Would, on that assumption, would the severability clause defeat your position?
I don't think the severability clause would defeat the position, depending on what New York law says. And it's impossible for me to tell you that now, because I don't know what the State law is. I know in another case under Pennsylvania law, they decided under special Pennsylvania law, not New York law, where they said that we can sever.
Okay,
but the key here is that the employer was not compelled to pay. We are being asked to incur an expense to which we never agreed.
Thank you, counsel. Counsel, did she meet her burden? How do we determine whether she met her burden? We start all over here and look at whether she met her burden.
No, I don't think that this Court should either engage in a fact-finding process or direct a lower court to, because I think there's an overriding public policy here that applies, and that is, as some of the questions adverted to, there's a $21,000 fee assessed against her if she wants to get to step one.
But how hard is it for her to put an affidavit saying, I can't afford it and here's why?
Because, Judge, I don't know what it means to say, I can't afford it. Should we have charts about if your net worth is X, you can't afford it? There's no question. I'm willing to concede that she has one.
In every single court, there are people that say we can't afford a lawyer, and there's an affidavit. You know, I'm unemployed, I've got 3 kids, I've got rent to pay, et cetera, and therefore I need a lawyer. And there's a determination made that the public will pay for their lawyer. Otherwise, they can't begin their lawsuit. This seems to me a fairly simple thing, too.
Right. I guess my answer to that is, Judge, there's no test, at least in this court, that says it has to be prohibitively expensive. In
So
the Schreiber case,
we shouldn't look at Green Tree?
well, Green Tree is being stretched beyond. Green Tree, the real issue was there was no proof of what the arbitration costs were. The arbitration forum didn't send a bill. There was no bill, and the Supreme Court in Green Tree said we don't even know what the expenses are.
What bothers me here is that in this case it may be easy to say, okay, the $21,000 is prohibitive. But if this was another employee of this investment firm and they made $2 million a year, I might not see $21,000 as being prohibitive.
Can I tell you why I still
Or
think
versus the litigation fees if it's comparable.
I still think the same policy applies. And here's the policy. We have a court system which is open to everybody, rich or poor, to vindicate their rights. And the economic barriers to getting there are very nominal, $210 in this court system. The test, and there's different tests by different courts. A good test used by the Cole case in the D.C. Circle, the Schenkel case in the Seventh Circuit, is the arbitration a reasonable substitute for litigation? And even if the man has a $2 million salary, the fact that he is being compelled to pay 100 times the admissions fee to get into arbitration that he would have to pay to get into the Supreme Court seems to me to violate a basic public policy.
Well, it's a private agreement and that everybody signed. I mean, the courts have nothing to do with this. These two people said if we have an issue, this is the way we're going to do it. And I tend to agree with everybody. You never know what the AAAs are going to be. But my real point was this. People will go in to see lawyers all the time, and they'll say, this is my case. It could be a discrimination case, it could be a negligence case, it could be something. And the lawyer says, $210 filing fee, but you're going to expect to incur $15,000, $20,000 in disbursements before we ever get to see a jury. Now, do you want to do that? And very often they'll say no. I'm sorry, I think I was hurt. I think I have a cause of action, but I just can't do it. And they walk away. And we don't even see or know those. In this one, two people agreed that this was the way they were going to go, and she's been told she had, if you want to go to arbitration, it's going to cost you $21,000. Do you want to do that or not? And she says, I want to do it, but I don't want to pay. And now the court says, that's okay, we'll make your employer pay. That just doesn't seem...
First of all, I disagree with you, Your Honor, respectfully, on the contractual interpretation. I disagree with all the 6 judges below. There are 2 absolute inconsistent clauses in this contract, because the contract incorporates by reference the AAA rules.
Aren't the words "except as otherwise agreed" in there?
Yes, but the AAA rules have an absolutely opposite rule. They say, even if you say that in your agreement, our rules apply.
So the parties say we take the AAA rules except as otherwise agreed, and the AAA rule says we don't care what you agreed.
Right.
Why shouldn't it be the parties rather than the AAA that get to decide whether it matters what they agreed?
Because there's a, well,
Both courts below found the manual takes precedence over the AAA rules.
this court could affirm that, but I do not know of any principle of law that says that. You're going to have to get into the new development of the common law of New York, because New York law says when there's a document which is incorporated by references, its terms apply. And I do not know any tie-breaking rule that this court has made. You're perfectly permitted to make the policy decision on contract interpretation, but I don't think you need to in this case, because you have a way to resolve this on a policy decision on whether or not this agreement gives Ms. Brady or any employee of this firm a reasonable substitute to arbitration.
Suppose it doesn't. Suppose you win on that, and that we agree with you the $21,000 was prohibitive. Why is not a perfect remedy for her to say, okay, go sue in court. We won't insist on the arbitration agreement?
That would be an incredibly Pyrrhic victory here, Your Honor, because her time to sue in court has lapsed.
Whose fault is that?
Well, she went to arbitrate because she believed that she could arbitrate. I don't think it's a good social policy to have everybody with an arbitration clause to go to court first to preserve their right to go to court when they know they're going to be...
Well, actually, what if I'm making this up as I go along, which may be a bad idea, but in Schreiber we said you can arbitrate conditioned on the defendant paying the fee. What if you say, what if we say we'll stay arbitration conditioned on their waiving the statute of limitations? Would that solve your problem?
I was thinking about that in the last few days as I prepared. I guess my only response about that that's no is that it hasn't been raised below by either side or addressed by the courts. But yes, that would give her, to answer your question directly, that would give her a vehicle to vindicate her rights at a reasonable price.
No one has a question.
Go ahead, Counsel. You have anything else you want to talk about? What about the severability issue?
Well, the severability issue is not a bar to imposition of public policy, one. And two, it is true. I did not argue at the Supreme Court you should find this because it's severable. However, this Court has made laws, the rule up, that when you attach a contract to your petition, its terms are deemed in play. And the contract was before the Court. And no, we did not argue severability, nor did my adversary argue that the...
But the agreement, your position is the agreement was before the Court.
Yes, the agreement was before the Court, and that is enough in the action notice pleading rules of this Court to make it a live issue for a court to go off and decide upon. Having said that, I don't think it's a fair interpretation of the appellate division majority decision to say it revolves around the severability agreement. It says it's void against public policy, and they voided against public policy, and I'm speculating here, but I believe they would have even if that contract, which had been imposed upon Ms. Brady, had not contained a severability provision.
Anything else, Counsel?
I have nothing to add. Thank you.
Okay. Thank you. Counsel?
Your Honor, just a few points. A lot of the argument is focused on the issue of whether or not she had the ability to pay and whether the agreement was void as against public policy. I think that the focus also needs to be on the issue of the appellate division's determination, which is unusual to say the least, which is to excise the provision and then make us pay. As the dissent noted, and the position we take is that creates an undue windfall for the plaintiff to the extent of $21,000, and it results in an additional $21,000 obligation for which we never contracted.
Suppose you persuade us on this, and you're saying essentially that the remedy should be the remedy in Schreiber, that either if you won't pay, she gets to go to court. What about the statute of limitations? Shouldn't that be conditioned on your waiving the statute under these circumstances?
No, not at all, because whatever she decided to do was her decision. Remember that she didn't just go to arbitration in the first instance. She used up at least 8 months at the State Division of Human Rights.
There's an arbitration clause in your handbook that she thought she was bound by. And she goes in and they say it's going to cost you $21,000. And she says, suppose she did say, I know you say she didn't say it, she says, I can't afford that. And after a few years of litigation, the court says, you're right, you can't afford it, go to court. Is it fair for you to say, sorry, too late?
Yes, it is, because she should have gone, I mean, her remedy was to go to court originally, as other plaintiffs have in other cases, saying, we're going to arbitration, and we want the court to invalidate that provision that talks about fee splitting. And she sat back, and she waited. And that's not our responsibility, that's her responsibility. We should not be forced to waive the statute of limitations to give her a claim now when she herself has sat back and not taken advantage of the rights and remedies that were due her. She could have gone into court and asked them to invalidate and compel arbitration, or certainly the arbitration could be conditioned on our waiver of the fees, and we pay. We haven't agreed to do that. She could have come to the court, and that could have...
Could you reasonably be put to your choice between paying the fees and waiving the statute of limitations?
No, I don't think so.
Why not? Sounds fair to me. It might sound fair to me. Why not?
As a private agreement between counsel as a way to resolve the litigation, certainly that's a possibility. We were never confronted with that. We were never asked to do that. But as a matter of law, the question here is whether or not she's met the standard under her burden, and whether or not the issue of severance, which is a key issue, was ever raised below, and where we never had an opportunity to address it, discuss it, or even confront it. Now she comes back and says, well, you know, okay, I may have screwed up, and statute of limitations may have run, So why don't you allow me to just waive the statute of limitations and let me go into court? I don't think that's fair. I don't think that's I don't think that there would be any precedent at all in any case law in a determination on appeal.
Okay, thanks. Thank you both.